Hey everyone, my name is Vojchehoske and welcome to Nebraska Landlord YouTube channel, where my mission is simple, and that's simply to provide information to the landlord, tenant, and property management communities. So in today's video, we're going to discuss Legislative Bill 1115. Now, as you know, the Nebraska Legislature is back in session, and they have put forth over 1,000 legislative bills. About 24 of them are real estate related. As of the date of this video, about 12 or 13 of them are landlord-tenant related issues directly. I'm going to spend the next few weeks going over each one of those that impact this community so you're better informed. The first one I want to start with is LB1115. It would substantially change how evictions are done in the state of Nebraska. And the biggest change is that the tenant would have a right to request a jury trial. As it is right now, landlord-tenant issues like evictions are done by bench trial, which means the judge is the final decision. The judge hears the case and then the judge makes the determination. If that happens, and what we have found in other jurisdictions throughout the United States that have similar laws and ordinances, it will definitely delay the time frame for evictions. Typically, it requires evictions to take 3 to 6 months before you can get the tenant out, sometimes 9 months depending on the jurisdiction. There are some specific things I want you to be aware of. So LB1115, the first thing that it does is modify Nebraska Revised Statute 761415, which really has nothing to do with a jury trial, but nonetheless, it does impact how you have to conduct business as a landlord or manager. And right now, the law says that you as a landlord or manager, you cannot provide or put provisions within your lease agreement that prohibits a tenant from exercising their legal rights or remedies under the Nebraska Landlord Tenant Act. And it's narrowly defined. It says the Nebraska Landlord Tenant Act. Now, LB 1115 expands that to include the Nebraska Landlord Tenant Act, but also any other federal or state law. So let me give you an example of the impact this would have. You couldn't have a provision in your lease agreement that prohibited the tenant from filing, let's say, a fair housing complaint against you. I don't think it's going to be a big impact in the industry because most landlords and managers don't have those type of provisions in there anyways, but I thought you should be aware of it. The meat of this legislative bill is in the jury trial provisions. So if it passes, let's take a look at some things that you have to know. Number one is when the complaint is filed. Now, what happens to initiate a lawsuit? In this case, the landlord or manager, they're going to file a complaint against the defendant, which is the tenant. That starts the lawsuit. That complaint has to contain certain essential elements. If LB 1115 passes, one of those elements is going to be the notification to the tenant that the tenant may demand a jury trial. So we have the complaint that's going to have that language in there. Now let's talk about the summons. The summons is where that tenant is going to be served that lawsuit or that complaint. The summons must also have language included in it that informs the defendant, or in this case, the tenant, that they have a right to a trial by jury. All right, so that's the second notification under LB 1115. The third part is when that tenant appears in front of the judge, on or before the time that that tenant appears for the first time in front of the judge. If the tenant has not demanded a jury trial, then that judge is required to inform that tenant at that point that they are entitled to a jury trial if they should want one. And then the last change, and probably the most problematic for the landlord or the property manager, is it modifies 761446. It removes the time threshold for the case to be adjudicated, and it leaves it open-ended. So if you read the proposed statute, it basically says that the action for possession shall be scheduled by the court as soon as it's practical for the proper administration of for justice. So essentially what this means is the judge is going to look at his or her docket and then make a determination when they can fit it in. And it allows them a lot more leeway than they have right now to schedule that. So it could be a week from now, or it could be 6 months from now. It just depends on the amount of activity within that judge's docket. And that's going to be a pretty substantial change in and of itself. Now, as I indicated earlier, I firmly believe that LB1115 is probably going to make its way through the legislature. And the reason is those 3 Supreme Court justices that went on the record stating that they believe that a tenant has a legal right to request a jury trial, and right now they don't have that right. So based on that, I think it's got a good shot at passing. The other thing to remember, that even if this doesn't pass, there's a really good chance that there's going to be another lawsuit that's going to be filed, and it's going to make it to the Supreme Court shortly, where the tenant will have standing, and it's going to be over the issue of they didn't have a right to a jury trial, and all they need in the Supreme Court is to flip one more Supreme Court justice, and it'll be the law of the land anyways. And that's why I think that this particular legislative bill has a lot of legs, and it's probably going to pass. That's all I got in today's video. I'll see you in the next video.